recently did a video about the 3 different ways that you can add or remove a beneficiary to an irrevocable trust. I didn't really go into great detail about either one of those 3 different avenues to facilitate that, but today I want to talk about decanting assets from one trust to another trust as a means of adding or removing beneficiaries. So let's get into it. All right, adding and or removing beneficiaries from an irrevocable trust can be very complicated. So there's a few different options. So the first one historically has been to seek a judicial modification, meaning you petition the court and then a judge over the court will then decide whether or not there are the legal grounds, statutory grounds, or the judge themselves has discretion to be able to allow for this adding or removing of beneficiaries. So it can be very complicated. There may be the ability to do it. There may not be the ability to do it. The second thing that I've focused on in my other previous video was a trust protector. So some states allow for trust protectors, and this person or committee can facilitate the adding or removing of beneficiaries to an irrevocable trust. But today we want to talk about decanting. Now, it's a little different than the first 2 options. Decanting is when you take assets from an original trust and you decant or assign or move them to a new trust. Now, the reason that you might want to do that is because you're seeking a complete overhaul from the original trust. So it might be more efficient, or it might be necessary if maybe there's a change in trust laws or tax laws, or in personal circumstances or financial circumstances, family dynamic, whatever it might be. There might be this reason why you need to just completely start from scratch and create a new trust. So when you're creating that new trust, you might remove beneficiaries that were named in that first original trust, or maybe you'll add new beneficiaries to that second trust that were not in the first trust. So there are different reasons that you might be able to do this, or I should say maybe there's different laws that could allow you to do this. And each state has different laws around what you can and can't do related to decanting. So just because you can decant assets from an original trust to a new trust doesn't mean that you can do it under every single circumstance. So states that have really robust or really well-defined decanting statutes are going to tell you when you cannot decant assets from original trust to new trust. So you want to make sure, and then not only that, it could cause a lot of problems. So we're going to look at the privacy aspect of this as well. So the privacy aspect of this is that if you have an original trust and you want to decant to a new trust, do you have to let the beneficiaries of that original trust know? Do you have to give them notice that you're moving assets from the original trust to the next trust? And the answer is it depends. So it's going to be contingent upon whatever state law says. South Dakota is recognized as being the best trust jurisdiction in the United States. Nevada, Delaware, Alaska, Wyoming, Tennessee, Ohio also have really strong trust laws, but South Dakota, for a variety of different reasons, is recognized as being the best trust jurisdiction, particularly because it has such well-defined, flexible, and robust decanting statutes. Now, one of the advantages of South Dakota is that you do not have to give notice to beneficiaries of the original trust that you're decanting to a new trust. That could be very, very advantageous if you have some beneficiaries who might be prone to conflict or might be confrontational and they might want to challenge things. The other thing that you have to keep in mind is that you may not be able to decant to a new trust unless the distribution provisions are the same exact from the new trust to the old trust. So it might give the trustee complete discretion to make distributions to the beneficiaries, or it might say that you can make distributions according to an ascertainable standard, which is Health, Education, Maintenance, and Support, HEMS. It's an IRS standard. So in some circumstances, you may not be able to change the distribution standard. However, South Dakota has very flexible laws around this. So you can change the distribution, even if there are the distribution standards, you can change them from one trust to the next trust. You can also remove what's called a mandatory income interest. So in that first trust, if it says that all trust income has to be distributed to the beneficiaries, you could move it to a new trust that has removed that mandatory income distribution. Maybe it doesn't make sense anymore. Maybe it's a decision that's driven from tax purposes, or maybe you don't want the beneficiary to have access to maybe that amount of income if it's generating a lot of income. Or maybe you want to preserve it in the trust to help build up the principal over time so it can continue to be invested. So that's one aspect of it. Another aspect is whether or not the second trust or the new trust can have what's called a power of appointment. So maybe you give the beneficiary the power of appointment, the ability to assign or appoint assets in that trust to other people who are not beneficiaries of the trust. So state law is going to dictate whether or not you can accomplish that. And then also another aspect of this is whether or not you can accelerate a remainder beneficiary's interest. So often, let's just say a spouse sets up a trust for the benefit of another spouse, an irrevocable trust for the benefit of another spouse, and then they'll name the children as the remainder beneficiaries, meaning that when that spouse passes away as beneficiary, then the children will then become the current beneficiaries of the trust. So some states, when you set up the new trust and decant assets over, you may not be able to move those children up to current lifetime beneficiaries, meaning the spouse and the children would then be the current beneficiaries. But in a state like South Dakota with very flexible laws, you can actually move those children up and you can accelerate the remainder beneficiary interest. So meaning you don't have to wait for that spouse to pass away. So those are a few different things to look at. Not all states have equal decanting statutes. South Dakota is widely recognized as having the most flexible, as well as they have privacy laws, quiet trust laws, asset protection trust laws that coupled with this decanting statute that make it the best trust jurisdiction in the United States. Whereas other states, they might have strong trust laws, but they may not be flexible when it comes to the decanting aspect. So I always tell clients, if you're in a position to be able to shop around for which trust jurisdiction is the best one for you, but why not look at South Dakota specifically so you can have the most robust, flexible trust laws that are available to you.